Hello and welcome. After months of legal battles now, Nigeria's Supreme Court has finally resolved the dispute over the September 2024 Edo governorship election, affirming the victory of APC's Monday Okpebholo and dismissing the appeal filed by the PDP and its candidate, Asue Ighodalo. In a unanimous ruling on Thursday, July 10th, a five-member panel of the Supreme Court led by Justice Mohammed Garba dismissed Ighodalo's appeal, describing it as lacking in merit. The court said it found no reason to overturn the concurrent decisions of the Court of Appeal and the Edo State Governorship Election Petition Tribunal, both of which, of course, affirmed APC's Okpebholo as the duly elected governor of Edo State. The court also held that the appellant failed to call relevant witnesses to support key pieces of evidence, particularly those related to the bimodal voter accreditation system BVAS machines in relation to their allegations of overvoting. So it's the end of the road for Ighodalo's quest to get the election of Okpebholo now overturned by legal means. In his reaction to the Supreme Court verdict, Mr. Ighodalo said, quote, "Though I accept the finality of its judgment, I do not and cannot pretend that what was delivered amounts to justice," end of quote. All right, joining me now to unpack all of this is Libro Soshuma, who is a legal practitioner and also has been involved in several election petition cases in the past. Also joining us is Nelson Ekojimi, who is a public affairs analyst and also an observer during the Edo governorship election last September. Gentlemen, thank you very much for coming on the program. Let me start with you, the lawyer, Libros. Give us your take on the verdict of the Supreme Court. Any surprise at all? This was a unanimous verdict, the same way we saw it at the level of the Court of Appeal and also the level of the Election Petition Tribunal.
Yeah, DEJI, thank you very much. First and foremost, I would want to apologize. My internet is acting up. There are no surprises. I saw it coming. The Supreme Court, there's already a precedent for this, the Oshu election, the amendment to Section 137, on the ground that oral evidence, of documentary evidence, can be tendered without substantiating, what is contained in the document. And the Supreme Court, in the case of Oshu, that's Oyetola and Adeleke, heard that when there is inconsistencies in those documents, there's definitely oral evidence was necessary. And that brought us back to the fact that disputing electoral irregularity, you must call polling unit agent. It is not enough to tender documentary evidence without actually calling witnesses. So the same way it went in Osun was the same way it went in Edo. And then the moment the tribunal ruled, first and foremost, I would say when INEC refused to call witnesses at the tribunal, I knew that it was over. Our electoral jurisprudence is not perfect, but to a very large extent, it is a work in progress and they keep improving, year in, year out.
Now, one of the grounds for Ighodalo's appeal, of course, was the issue of non-compliance. He alleged that, that the election results were tampered with in 395 out of the 4,519 polling units. But then the tribunal and, of course, the Supreme Court concurred. Of course, the court's now saying that, look, 395 out of 4,000 over 4,000 polling units is obviously not substantial enough to declare an election, to void the outcome of an election. And then the Supreme Court going on to say that, look, the Court of Appeal now, that even if the election in those 395 polling units were to be cancelled, it still would not have affected, substantially affect the outcome of the election. Could you speak to us along that line? And of course, the issue of, you've actually touched on the issue of the witnesses, but then the court also going on to say, look, even the witnesses that were called were basically reliant on hearsay, and they were not providing concrete evidence.
Yeah, DEJI, take our mind back to 2003, so that, like I said, there are no surprises. These are precedent. The court works with precedents. Judgment and rulings are based on precedent. If you remember, in 2003, Obasanjo, the presidential election, I think it was, yes, the former president, Muhammad Buhari, challenged that Obasanjo's election up to Supreme Court. Supreme Court did rule. There was, I remember the judgment was 2-3, two for, two against Obasanjo, and three judgments led by Justice Nikki Toby read the majority judgment in that case, while Justice George Ogutade of the Supreme Court read the minority,
Yes.
judgment. And the majority judgment did acknowledge that there were irregularities in Ogun State. And that irregularity, because Electoral Act talks about substantiality, that irregularities were not substantial enough to vitiate the outcome of the election, even if you cancel the election in Ogun State. And so that became an established principle that you were talking about 2003. We are in 2025. That's 22 years ago. That principle had been laid. So today, 2025, simply what the Court of Appeal simply said, and the Supreme Court concurred, is that this principle has been laid long ago. When we talk about election irregularities, apart from the fact that you must call polling by virtue of the Supreme Court decisions in recent one, which is Oyetola's case, that you must call witnesses to substantiate allegations contained in the document, especially when there are inconsistencies. That there is need also for you to ensure that the allegations are substantial enough to void the outcome of the election. So in this case, out of 4,000 plus polling units, you are complaining about irregularities in 300 and something units. And the court is of the opinion that has laid down in the principle in Musa and INEC, that even if these 300 and something polling units were removed completely from the result sheets, that is, it will still not affect the outcome. What it means is that it is not substantial enough to void the outcome of the election.
Okay, let me come to you, Nelson. You observed that election. You were very much involved in the process. You saw everything. But looking at the Supreme Court verdict, or even looking at the verdict from right from the Election Petition Tribunal up to the Supreme Court, what have you got to say in terms of, as someone who, observed the election and the judgment by the courts?
Well, thank you very much, DG. What I can say is that the judgments right from the tribunal, the justices of the tribunal were 3 in number, and unanimously, the 3 of them dismissed the petition of Asu Egudalo. It went to the Court of Appeal, and again, the 3-member justices of the Court of Appeal dismissed his petition again, and it went further to the Supreme Court. And at the Supreme Court, the 5 justices, along these 3 layers of judicial adjudication, not even one justice, disagreed with his brothers. So what that tells you clearly is that the judgment is an affirmation of what transpired on election day. And like Liberals rightly said, the level of development that has gone into our electoral process is one that makes room for electoral malpractice almost impossible. And why do I say this? There's a beavers machine, and according to the regulations of INEC, once the number of accredited voters, is less than those who have voted, automatically INEC does not know whether it is party A or party B. It means an electoral malpractice has taken place. So INEC instantly at the World Collation Center will cancel that result of the polling unit. And again, what this brings to the fore is that like the Liberals has rightly said, in election, the most important witness is the polling agent, because it's the one that witnessed the exercise. So when you look at the petition at the tribunal, because I monitor the tribunal proceedings, the PDP candidate brought, documentary evidence, and when he was now made to bring to make oral testimony, he brought witnesses who were not the makers of those documents. You can imagine somebody speaking to the document prepared by another person. So in court, such witnesses are always dismissed as unreliable and not worthy of that testimony. So by and large, the judgment once again signifies victory for democracy, victory for the people of Edo State. And again, I want to disagree with Liberals, because you say the judiciary is looking for ways where people can, take their matter out of court. No, the judicial adjudication or judicial process is embedded in the electoral system, because the system, foresee a situation whereby somebody who has contested will definitely say, I have been robbed. And like we have witnessed severally, people contest the election, and when they lose and they say I've been robbed, and you ask them for evidence, they are telling the next thing, the person can begin to cry and say, can't you see I'm crying? Is that not enough for you to know that I have been robbed? And in law deals with facts and evidence and not emotions.
And, one of the key contentions of the PDP in this case is the issue of overvoting. And, they took that up to the Supreme Court. And let me just, what the tribunal said, when it gave a judgment, it said, look, to prove overvoting as alleged by Ighodalo and PDP, there's need to tender the voters register, the beavers machines and polling unit results or Form EC8A. And, overvoting was key to this case. Looking at the way the court ruled, what have you got to say about that now, sir?
No, the overvoting allegation was a mere hoax. Like I told you, when election takes place at the polling station, you have the party agents, you have observers, you have security agents, you also have the electorate as well as the electoral umpire. And there and then, you have witnessed the election where once you come to the polling station, if you are not accredited by the card reader or the beavers machine like we know now, you are not allowed to vote, because if you vote, then you'll be, you void the votes of, legitimate voters who have been accredited by the machine, because the electoral law gives INEC the powers to make rules and regulations.
So you mean overvoting can actually be detected?
Immediately, because if the number of accredited voters is 90 and the number of ballot papers sorted and counted amounts to 91, the question will ask, how did that one person vote? How did he get accredited? Or how was he able to access the ballot paper? Because without the accreditation, you cannot access the ballot paper. If you access the ballot paper without accreditation, that means you want to commit electoral malpractice. So overvoting, even at the polling station, everybody will start raising eyebrow, and immediately you leave the polling station, the parties have their agents at the collation center at the ward. Immediately you raise any objection to such result, the ward collation officer of INEC will void that result.
Liberals, I know you want to say something on this. I mean, the issue of overvoting, it was a big, a big issue in this case. But eventually the PDP was not able to prove it.
Overvoting is a very simple issue. If you're alleging overvoting, all you simply need to first prove at the polling unit and at the collation center when overvoting is noticed, all they need to check is what is the number of actual votes and the number of accredited voters. Before the Electoral Act Amendment 2022, overvote the number of actual votes and of a number of registered voters. It is the registered there. But with the amendment of the 2022 Electoral Act, the Supreme Court ruled in the same Oyetola's case. That case is sui generis. It addressed a whole lot of issues in as far as this Edo election petition is concerned. And the court ruled that for overvoting, the new rule is that once the number of actual voters exceeds the number of accredited voters, because now you have a device, technology, the beavers, to accredit. So you no longer have to refer to the electoral register. So that became the new law. So in this case, and what did the Supreme Court say in that same Oyetola's case? Mind you, that case was in favor of the PDP, who are complaining today. And what was the Supreme Court's position? That for the APC who were alleging overvoting, they needed to bring the primary evidence, which was the beavers machine, place it side by side with the number of accredited voters, because the beavers machine was the tool, the device used for accrediting, and then place it with the number of actual voters and then the result sheets. The result sheets.
That's the form
because
EC8A.
if you are alleging that, can you hear me?
Yes, that's the form EC8A.
Yeah, the form EC8A. So that which is the result sheet. So if you are alleging that there are discrepancies in figure, it is common knowledge, it is elementary for you now to bring all of the documents and the devices to show the discrepancies one after the other. But failure to do that was detrimental to your case. And then lastly, I also need to correct an impression where Nelson disagreed with me. What I am saying is that the court, I'm not saying the court is not interested in adjudicating matters. What the court is simply doing is saying, we can't just interfere in our election on the ground of flimsy excuses. The people, democracy is about the people. The people have decided. And so to that extent, once the people decide, the evidence must be strong and compelling enough for the court to interfere in the outcome. And mind you, there is presumption of correctness in favor of INEC. Once INEC declares result, the presumption in the mind of the court is that everything had been taken into cognizance, like the issue of overvoting, because if you had raised it at the polling unit and INEC had looked at their document and they discovered that there was overvoting, they would have cancelled the result. But in the absence of that, the court is not going to say because you raised it. And so that's what I meant by saying that the court also is distancing himself from interfering in the processes of our election after the people have decided.
All right, I think we just have to leave it there. Libros, thank you very much for your insights. And Nelson Ekojimi, thank you also for coming on the program and sharing your thoughts with us. I really appreciate it. Unfortunately, we've run out of time. And Libros, we're having issues with your audio as well. But thank you, gentlemen, for coming on the program. We'll take a short break and we'll be right back. Stay with us, don't go away. Opinions are free, facts are sacred, but truth is universal. How, in practical terms, can we, for instance, de-escalate the tension?
The president must see himself as the president of the Federal Republic.
We know where the enemy is. 3 places. The Lake Chad Basin, the border area between Nigeria and Cameroon, and then the Sambisa Forest.
On DEJI 360, we give you a complete dose of everything. Opinion, facts, and undiluted truth.
I hardly believe what politicians say in this part of the world.
A new Nigeria is possible, a future is possible.
We delve into the issues, dissect it so that you can understand it, use it to take action.
I don't think there's any need for any governor to look for grant for ranching.
DEJI 360, dissecting the issues.